My name is Rocio Sanchez Flores and I'm an immigration attorney in SFR Law Corporation. In this video, I'm going to talk about how the assistance programs that immigrants access through this pandemic may affect their future immigration goals due to the public charge rule. First, I'm going to give a brief explanation about the public charge rule. This is not a full discussion of the rule, but rather an explanation for you to understand if you may be affected by this rule when accessing assistance related to COVID-19. The public charge rule affects all applications and petitions submitted on or after February 24 of 2020. So if you have an application or petition pending that was submitted before that date, you shouldn't worry about being affected by the public charge rule for those applications. Now, what's the public charge rule about? The government has said that it is a self-sufficiency test for non-US citizens. That means that the government wants to make sure that foreign nationals do not depend on public resources to meet their needs when they are in the United States. Rather, foreign nationals should rely on their own capabilities. That means they should be able to work to meet their needs, and when necessary, they should use the resources of their families or sponsors instead of public resources. Then we face two main questions. When does using public resources make you a public charge, and who is affected by this rule? Using public resources make you a public charge when you have received 12 months worth of public benefits within a 36-month period. So it is counted by the number of benefits received within a certain amount of time. If you receive one benefit per month, it will take you 12 months to become a public charge. If you receive 2 benefits per month, 1 month will be counted as 2 months for the public charge determination. If you receive 3 benefits per month, it will take you only 4 months to become a public charge. Now, who is affected by this rule? People changing or extending their non-immigrant status, or people seeking admission to the United States or adjusting their status, that is, people trying to obtain a green card. I separate it this way because people changing or extending their non-immigrant status need only to prove to the immigration officer that they haven't received 12 months worth of benefits within the past 3 years. On the other side, people asking for admission to the United States or trying to obtain green cards need to show that they have not received benefits as previously explained, but also that they are not likely to become a public charge in the future. So, people trying to obtain a visa for first time and thus adjusting status need to be able to convince the immigration officer that they are not going to become a public charge in the future, that is, tomorrow or in 20 years. Yes, it is a complicated rule, and you should consult an immigration attorney if your case is slightly complicated. But our topic today is if your immigration goals could be affected if you use assistance related to COVID-19 that the government has made available for immigrants during this pandemic. The government will not consider, in its determination of public charge, the receipt of Medicaid for the treatment of an emergency medical condition. So it is very important for you to remember that the federal government has said that using Medicaid for the treatment, prevention, or testing of COVID-19 will not make you a public charge. Whether you are documented or not, if you do not have insurance, you can access the necessary treatment and testing for COVID-19 in California through medical emergency services. Unemployment insurance benefits, disability benefits, and paid family leave are earned benefits, and they do not count against the public charge determination. Make sure to check that in your state these benefits are available for immigrants. In the state of California, disability benefits and paid family leave are available also for undocumented immigrants. Also, benefits received by U.S. service members who at the time of receiving the benefit or at the time of filing the immigration application were enlisted or serving in the U.S. Armed Forces will not be considered for the determination of public charge. The government will consider in its determination of public charge any federal, state, or local cash assistance. I mentioned CalWorks in previous videos for undocumented immigrants living in California. In that case, you need to be careful about who is listed as the person receiving the benefit. Also, the government will take into account in its determination of public charge the Supplemental Nutrition Assistance Program, formerly known as food stamps, Section 8 housing assistance, and the public housing under Section 9. The public charge rule clarifies that only benefits received directly by the applicant for the applicant's own benefit or where the applicant is listed as the beneficiary will be considered in the determination. So a public benefit received by one or more persons in your household, maybe your children, will not be used against the immigrant filing the petition with USCIS unless the immigrant is listed also in the benefit as a beneficiary. Also, federally funded Medicaid will be counted in the determination of public charge, except as mentioned earlier for emergency treatment. However, state, local, or tribal medical healthcare services will not be counted against the determination of public charge because they are not federally funded. Finally, I want to mention the recovery rebate that some people will be getting from the federal government. This is not financial assistance. This is a tax credit and therefore is not counted in the public charge determination. You can find all the assistance programs that immigrants can access through this pandemic in our video series. The information and videos are divided in three main categories: COVID-19 assistance for documented immigrants, COVID-19 assistance for undocumented immigrants, and the one we covered in this video, how accessing COVID-19 related assistance may affect those subject to the public charge rule. In our website, in the description of the video, you can find links to official government websites where you can access these assistance programs. Remember, you can contact us if you need help with any immigration-related case. USCIS is still receiving petitions, and we have a fully functional, socially distant immigration practice. SFR Law Corporation, helping you to achieve a more secure and thriving future in the United States of America.